Good morning, afternoon, or evening, whatever applies to you in this particular situation. Hi, my name is Phil Albrechts. I'm a hearing examiner for 14 counties and cities and also city attorney. I've been doing that since 1989, so I've had the opportunity to work a lot with planning commissions and city councils and other city boards and commissions in dealing with the Open Public Meetings Act. So today, in the next about 20 minutes or so, I'm going to teach you everything you need to know about the Open Public Meetings Act. So you can meet mandatory state training requirements, you can understand how the act applies to your community, and also probably the most important thing, so you can ensure that your decision-making process is open and transparent like the Open Public Meeting Act, which I'll be calling the OPMA, wants to see. So now, I'm going to be going over a lot of details on how the act applies and exceptions to it and exceptions to exceptions and that kind of thing. But I don't want you to lose sight of the fact that this actually is a very simple requirement, and it's very easy to understand if you just keep two principles in mind. The first principle is that the Open Public Meetings Act requires that if you have a meeting, that meeting has to be open and available to the public. They have a right to attend, and you have to provide notice of the meeting so that the public knows that meeting's happening, so they can go there and watch what's going on. That's the first principle. The second principle, and this is something this is where people get in a lot of trouble, they don't realize this, is anytime you have a quorum of your decision-making body, your planning commission or your city council, and they're engaged in any action which is defined by the Open Public Meetings Act as including any discussion or deliberation, that qualifies as a meeting. So even if you're outside in a parking lot when you're done with your planning commission meeting, and you're talking about what happened at that planning commission meeting, that probably qualifies as a meeting under the Open Public Meetings Act, and there should have been notice, and the public should have been given that opportunity to attend. So just keep those two principles in mind, and I think you will avoid 90% of the problems that you can encounter with the Open Public Meetings Act. So now let's get down to the details. Now, the Open Public Meetings Act has been on the books since 1971. That's several decades at this point. And so, of course, in all that time, we've had a lot of opportunities to develop a substantial number of cases that interpret the act and how it applies to cities and counties. Now, unfortunately for cities and counties, most of those cases start off like this, and I'm paraphrasing very loosely, but we, the court, rule against the city or county, and we feel we have no choice because of the really strong purpose clause of the OPMA. And let me tell you, that purpose clause is really powerful, and I'll read it to you directly, and it's on the slide as well here. So what it says: the people of the state do not yield their sovereignty to the agencies which serve them. The people in delegating authority do not give their public servants the right to decide what is good for the people to know and what is not good for them to know. The people insist on remaining informed so that they may retain control over the instrument they have created. It's almost like a declaration of independence for open and transparent government. Our legislature actually copied that from a public initiative which created the Public Records Act, which provides that records should be available to the public. And so the same principles apply to the OPMA as well. There's another statute in the OPMA that also makes it really tough for cities and counties when they're dealing with OPMA lawsuits, and that is a provision that states that the OPMA is to be liberally construed, which means essentially that if there are any gray areas, if it's an issue of open and transparency, the court's going to find a violation. So with that really strong purpose clause and with that liberal construction clause, if there are any gray areas, if it's questionable at all, the court's going to find that the Open Public Meetings Act applies. So that means in your particular case, the most important thing to do is if there's any doubt in your mind as to whether or not you're holding a meeting, treat it as a meeting, and then you'll be safe. As I'll be discussing in a few minutes, it's not that hard to comply with the Open Public Meetings Act if in fact you're holding a meeting. It's not a big deal. So, if it looks like it's going to be a meeting, just treat it like one and you'll be all right. All right, let's move on now to the one statute that is a primary requirement of the Open Public Meetings Act. And this is, where everything else essentially falls from under the Act. And I'll quote from it directly. All meetings of the governing body of a public agency shall be open and public, and all persons shall be permitted to attend any meeting of the governing body of a public agency except as otherwise provided in this chapter. All it's saying is if you have a meeting, the public has the right to attend. Now there's just two, kind of legal issues, questions there, in that simple sentence. One is, what's a governing body? And two, what is a meeting? So let's first deal with the governing body. The statute says it's a multi-member board or commission, that is involved in policymaking or rulemaking for that particular jurisdiction. All right, so planning commissions, of course, the city council or the county commissioners can't amend their development regulations or their comprehensive plans unless they get the recommendation from the planning commission first. You are clearly a policymaking body, you're a governing body subject to the act. And essentially, there are a bunch of attorney general opinions on this, but it's any board or commission that's created by an ordinance or resolution of a county or city is going to be a governing body. And again, as always, if in doubt, the particular committee that you have, if you have a question about it, treat it as if it's subject to the Open Public Meetings Act. All right, now let's get to the good stuff. What is that meeting? And I've already kind of spilled the beans at the beginning of my presentation. That's essentially when you have a quorum plus action. Now I'll kind of explain where that rule of thumb comes from. First of all, if you look at the definition of meeting in the OPMA, it's kind of funny. It says a meeting is a meeting at which action is taken. A definition is never very good if it uses the word that it's defining, but that's what we have under the OPMA. The definition that has more substance here is what's that action that occurs at a meeting that's of significance. And it goes through a laundry list of what constitutes that action, but essentially final action, which is any final decision like a vote to recommend approval of a comp plan amendment or a vote to approve an ordinance, that's clearly going to be an action, and you're going to qualify as a meeting if you're doing that with a quorum. Also any discussion or deliberation, and that's the tough part, is that anytime you're discussing or deliberating anything related to city or county business that's within the jurisdiction of your governing body, your committee, commission, or board, that also is subject to the act. And as I mentioned before, that's where communities run afoul of the act a lot of times because they think they're just having a harmless conversation at a party, but lo and behold, there's a quorum of decision makers in that conversation, and they're having themselves a meeting. Now, where does that quorum requirement come from the quorum plus action rule? Well, that actually isn't mentioned in the statutes. That comes from the case law and the attorney general opinions, which kind of come to the common sense conclusion that, planning commission really can't accomplish anything or do anything unless it has a quorum. If you vote with less than a quorum to make a recommendation, that recommendation really isn't binding. It has no legal meaning. So, again, if you have a quorum and you're involved in any discussion, deliberation, or final action, you have yourself a meeting subject to the act. Okay, now up until this point, I've been talking about the action plus quorum rule. Some of you may be wondering, well, what's a quorum? I haven't actually defined that yet. Let me do that at this point. A quorum essentially is just a majority of your decision-making body. Without a majority of that decision-making body, as I mentioned before, none of the actions you take have any legal or binding effect. And usually a quorum is a majority of the members. Your local ordinance or bylaws may have a different definition, but it's going to be around that majority for the entire body. And there, as I mentioned before, I'm going to be talking about exceptions and exceptions to exceptions. There is an exception to the quorum plus action rule. You can actually be holding a meeting without a quorum in 3 limited circumstances. One is if the committee is acting on behalf of the governing body, all right? So you just have 2 of your 5-member planning commission, and they've been tasked to make some decisions on behalf of the planning commission as a whole and direct staff to do A, B, C, or D. Well, in that particular situation, even though you don't have a quorum, they're holding a meeting, and that meeting should provide some notice for the meeting, and the public has a right to attend. Also, if the committee is holding a public hearing or it's taking public testimony as well, even if it's not a quorum, still subject to the Open Public Meetings Act. Now we have the basics here of the quorum plus action rule. Let's go through some quick examples, some real life examples of when you're holding a meeting. Now, one of the interesting things about the Open Public Meetings Act to keep in mind is, as I mentioned before, it was adopted in 1971. This was before anyone had ever heard about emails or texting or blogging or messaging or any of that kind of thing. And without that really strong purpose clause and that liberal construction clause that I talked about before, people would have a really good argument that, well, the OPMA doesn't apply to email exchanges or texting exchanges because it didn't exist back when the legislature adopted it. They couldn't have had it in mind. But of course, now with that strong purpose clause, it's fairly clear that if you're having a discussion that's by email instead of in a room in real time, it's still going to qualify as a meeting. And we actually have a court opinion that says that email exchanges that don't happen all at the same time, that happen over several days, if you involve a quorum of people, that can constitute a meeting subject to the Open Public Meetings Act. And by extension then, I think it's fairly safe to say that texting and blogging, where you have, say, a majority of planning commission members engage in a discussion in the responses to a blog or something, all those types of exchanges, two-way communications are going to be subject to the Act. Another real-life examples of meetings I mentioned before are that, like, site visits, actually. If you're out doing a site visit and you have a majority of your planning commission members in the car driving out to a site to look at it, and you're talking about the project, that's going to be clearly subject to the Act. You're out in the parking lot talking about it after the meeting, that's subject to the Act. If you have a tradition, and this is very common in communities, of you all go out to Denny's or something after your meeting to blow off some steam, if you've got a quorum and you're laughing about the silly things that Joe said at the meeting, that could actually be subject to the Open Public Meetings Act. So be very careful. All right, the next topic I want to address with the OPMA is extremely significant because communities have had a lot of problem with this in the last few years, and that's email exchanges. I want to get in a little more detail about that. Now, first of all, to be clear, the Open Public Meetings Act deals with conversations and deliberations, as I mentioned before. That means a two-way street, type of communication. If you have a planning commission member, city council member that just sends out information to everybody without expecting a response or getting a response, that's okay. It doesn't apply to passive transfers of information that don't involve that discussion. Another point to keep in mind with emails is that, even if only 2 planning commission members are sending emails back and forth, if you have another 3 that are CC'd, they're considered part of the conversation. They're going to count towards that quorum, and you're going to be having yourself a meeting. So if, it's perfectly fine to email your buddy on the planning commission and say, oh, what do you think about, what happened tonight? That exchange is not going to qualify as a meeting. But if you CC a couple other members of the planning commission and you hit that quorum numbers, then you're going to have some problems. Now also staff, staff members are not considered a member of the governing body. So when they send you agendas by email and hearing packets and that sort of thing, that's perfectly fine. They're not a member of the governing body. They're not subject to the Open Public Meetings Act. Therefore, they're not subject to the quorum. Now, if they send out an email with that information and then this sparks a conversation amongst planning commission members in an email exchange, then you have violated the Act. So you always have to worry about that. 2 other points now getting a little beyond the Open Public Meetings Act, but this is really important for you to understand, is emails are considered to be public records subject to public disclosure under the Public Records Act. All right, so if you send out an email to another planning commission member and you're discussing planning commission business, an item that may come up on the agenda or actually that has already been discussed even, anyone can go to City Hall and say, I want a copy of all the emails that planning commission member Smith sent out to his friends within the last month. And by state law, the city has or county has to provide those copies to the person who requested it. All right, and that's why a lot of communities now they give email accounts to their city council members and planning commission members so that all their discussions are done through that city or county account, and those emails are easily accessible for public disclosure requests. That can be very embarrassing for people. You think, a good friend of yours is on the planning commission, that's a private conversation. Well, if you're talking about city or county business, it's not a private conversation, it's public. And the rule of thumb with this is that, whatever you tell other people in regards to city or county business in an email, make sure you wouldn't be embarrassed if it was put on the front page of the newspaper, because a lot of times that's where it ends up in these record requests. And finally, another point to be made by emails is that they are public records subject to retention under our state retention laws. It's actually considered a felony to delete a public record that is required to be preserved. All right, a lot of public records, they have a record retention schedule that's put together by the state archivists. And a lot of records, if you're just talking about scheduling a lunch meeting or something, you can delete those immediately. But any records that have any substance to them, any policy discussions, a lot of times those have to be maintained for 7 years. And again, this is why a lot of communities now give email accounts to their planning commission members and city council members and county council members, so that those records are retained at City Hall, and the people sending emails from their private PCs don't have to worry about retaining them. Now we've identified what a meeting is. I think that's probably one of the more important things you need to know about under the OPMA, because once you understand what a meeting is, you're going to avoid a lot of those violations that become major embarrassments for people when it gets in the papers or serves as a lawsuit or that kind of thing. So now let's talk about what you have to do if you do hold a meeting. All right, you decide that conversation out in the parking lot is a meeting. So what are you supposed to do under the Act in order to make that legal? Well, 2 things basically. One, you have to provide some notice for it. and as I'll be discussing, the notice part isn't really a big deal. And two, the public just has that right to attend. So let's get a little bit more into what it means for the public to have that right to attend. All it really means is the public has a right to be in the room where they can listen to what you have to say. That's essentially the only right they have under the Open Public Meetings Act. The right to attend does not mean that they have a right to testify. I mean, people are, that's a common point of confusion, and it's simply not true. The OPMA does not give people a right to interject their comments into your meeting. Now, if on your agenda you say, you put one item that says public comment period, that's something that you regularly give to people, then they have a right to talk because you voluntarily gave them that right to talk. But there's no state law that says you have to put a public comment period on your agenda. Now, of course, state law in some cases is going to require a public hearing for development permit applications and things of that nature. And there the public has a right to testify. But with, under the Open Public Meetings Act itself, there's no right to say anything at a meeting. The right to attend also does not mean the right to disrupt, all right? If people are making a bunch of noise or throwing things at you, cat calls, that kind of thing, the OPMA actually has a provision that explains how you can have those people removed from the room if they do that kind of thing. Under most local definitions of disorderly conduct, that's a crime. One of the elements is disrupting a lawful assembly. And of course, your planning commission meeting or your city council meeting is a lawful assembly. And if they disrupt it where you can't conduct business, you can call in the police and have them removed. Just make sure they really are being disruptive, because if you have them removed for just exercising their free speech rights or something, that can be, the basis for a false imprisonment charge, false arrest, all that kind of stuff. So it's a pretty dicey thing. You want to get your city attorney or county prosecutor involved when you get to the point of having people thrown out of the room. It does happen, but thankfully not too often. Now, a couple don'ts related to the public right to attend. You can't condition their attendance on signing a sign-in sheet or providing their address or something like that. It's a real common practice in public hearings to have people sign in and state where they live, that kind of thing. But to have them sit in the room, you can't make them provide that kind of information. Also, you do have to allow the meeting to be recorded. If they want to tape record it, that's fine. All right. Now, if the recording is disruptive, like they bring in some really bright television lights and you got your council members squinting at each other because the lights are so bright, you can stop them from doing that kind of thing. But it truly has to be disruptive to the meeting in order to get to that point. All right, so next let's deal with that notice requirement, which I promised is fairly simple, and it really is. You have two types of meetings under the OPMA, regular and special. The regular meeting is your regularly occurring meeting, and the OPMA simply requires that you adopt something that says when that regularly occurring meeting is going to occur. So in most city and county codes, they actually say the county council or the city council will meet the second and fourth Tuesday of every month, all right? And there you go, you've complied with the act. You can also do that in your bylaws or that kind of thing. Beyond that, actually, except for a law that was just adopted last year, and I'll be talking about that shortly, there's no other requirement in the OPMA that requires any notice for those regular meetings. There's a statute outside of the OPMA that basically provides that cities and counties, or at least cities, need to come up with their own notice procedures for their meetings. And the way a lot of communities have dealt with that is they simply say, we will post the agenda for our meeting at least 24 hours in advance at the library, at the post office, and at the kiosk right side of the city council chambers. And that's perfectly okay, and that's the way a lot of communities like to operate. Like I mentioned, there's another law that's added to that, and I'll get to that in a minute. Now, special meetings are a little more involved. The notice for that, basically 24 hours in advance, you have to give notice to all of your decision makers you're going to have the meeting. And you also need to let the media know, any media that has given you a written request, to be apprised of the fact that this is coming up. And that notice needs to contain essentially the items that you'll be discussing. And the only items that you can then discuss at that special meeting are those that are listed in your agenda for your special meeting. And that's something very different from a regular meeting, where you're fairly free to add items to the agenda. There's some legal debate about whether or not you can adopt an ordinance that's not on your agenda. But beyond that, for a regular meeting, you can add just about anything to your agenda. But for special meetings, you are limited to what that agenda says. So, all right. So I mentioned before that there's a law that was adopted last year that's added to these noticing requirements. And that new law essentially is that you have to post your agenda on your website at least 24 hours in advance. And the law does not apply to agencies that don't have websites or that employ fewer than 10 full-time employees, all right? And the failure to comply with that isn't going to subject you to the OPMA penalties that apply to other types of violations, which, and those penalties, as I'll be discussing, is that the action that was taken is void, the person that sues you gets their attorney fees if they win. So, now another important aspect of the OPMA that deals with notice procedures is continuing the meeting. The OPMA actually calls it adjourning a meeting, but I think most people, they understand that the requirements more clearly if you call it continuing a meeting. If you need to continue the entire meeting to another date, I'm not talking about just an agenda item, I'm talking about continuing the entire meeting. You know, say you're going on and it's 1 o'clock in the morning and everybody's really tired and it's like, let's finish this in a couple days on Thursday night. Okay, then under the OPMA, continuing that meeting, you just have to post the agenda of what you're going to continue to discuss at the door or close to the door of where you're meeting. You need to provide the 24-hour notice to all your decision makers and also to any media that's requested notice, and then you're pretty well good to go. Just don't forget to put that agenda on the door. All right, so now let's get to some of the grand exceptions of the Open Public Meetings Act. These are called the executive sessions. Our state legislature did recognize when it adopted the OPMA that there are certain circumstances where openness and transparency actually is counter to the public good. And there's a long list of what types of meetings aren't subject to the OPMA. I'm of course only going to focus on the ones that apply to cities and counties, since that's the most of the audience here. The first category is personnel issues. If you're talking about employee performance, a charge against a public official, if you're talking about the qualifications of someone you're going to hire or appoint to a particular board or commission, those types of issues can be handled behind closed doors, because the legislature just felt that it's a little difficult to be frank and honest about what you think about someone's performance if you have to do it out in an open meeting. And frankly, it can be very embarrassing, of course, to the person they're discussing as well. But the final decision has to be done out in the open. Now, the one that's probably going to happen more often for planning commission members is what they call the litigation exception, or the potential litigation exception. And that's where if your attorney's present, you can talk about a lawsuit that's been filed, a lawsuit that may be filed, or the most common, the legal risks of moving forward with whatever action you're thinking about doing, if an open discussion of those legal risks would be adverse to the city or county. This is used quite often. I mean, one of the things, as I mentioned before, you really got to be careful with is the attorney has to be there. Now, I think it's probably, there hasn't been a case on it, but it's probably perfectly fine to have your attorney do it by speakerphone. That's the way a lot of communities do it. But one way or another, the attorney there has to be there, because supposedly the entire point of this potential litigation executive session is to talk about legal risks, and the only person who can give you the accurate information on that is your attorney, of course. And then the final type of executive session is real estate, the purchase and sale of real estate. If it could affect price, you can do that behind closed doors. I mean, think about it. If you're thinking of buying a piece of property and you're telling your public works director, oh, Joe, you're authorized to offer $50,000 for that piece, but we're going to give you some negotiation flexibility to go up to $100,000 if they're really tough. Well, obviously, if you say that kind of statement out in the open, you're going to be paying $100,000 for that piece of property, and that's why the legislature said you can do that behind closed doors. Just a couple rules dealing with executive sessions, procedural rules. So before going into exec session, you have to announce what the purpose of the executive session is. That announcement has to be specific enough so that someone could identify in that list of exceptions in the OPMA statutes which one applies. And then also very important, and it can really be a kind of a pain from a procedural standpoint, is that you have to announce when you estimate the executive session will be over. Because a lot of these executive sessions can last for an hour or even longer. And the public may want to step out as you're going through this and deal with other issues and come back to hear what you have to say once you reconvene in an open meeting. So it's real important that estimate at least underestimate the amount of time you're going to do, because if you say it's going to take an hour, and then you're done in a half hour, the public's still outside thinking that you're not going to be talking yet, and that's probably going to be a pretty quick violation of the OPMA if you end up conducting any business while the public is still outside in the parking lot because they were told you weren't going to be doing that anymore. Secret ballots, another OPMA requirement, are not allowed. All your voting needs to be done, publicly so that people can see who's voting yes or no. So finally, let's deal with the penalties. What's the big deal here with the OPMA? Well, it probably what's not listed in the statute, the biggest deal is simply the loss of public trust. I mean, the media is really concerned and really focused on OPMA issues. They can't do their job in covering city business if there's any secrecy to it. So if a city or county board or commission is found to have violated, that usually makes page one of the local newspaper. So that's a big deal. You want to maintain that public trust. You want to stay out of the newspapers. But secondly, if you violate the act and it's a knowing violation, and that's an important term, knowing violation, the city attorney is sitting there telling you, don't discuss this issue, it's a special meeting and it's not listed on the agenda, and you say, we don't care, we're going to do it anyway. Okay, that's a knowing violation. You're going to be subject to a $100 penalty. Probably not covered by your insurance. Insurance doesn't cover intentional acts or knowing acts of that nature. So that's your out-of-pocket penalty there. More severe for the city itself is that if someone sues a city or county for an OPMA violation, they get their attorney fees if they win. If they lose, the city doesn't get reimbursed for its attorney fees, but if the person suing wins, they get their attorney fees. And then finally, really significant, any action taken during that illegal meeting is going to be voided. All right, so if you went through 2 years of hearings on a huge development project and you, for whatever reason, violate the Open Public Meetings Act and it gets appealed and it's court, and 2 years later the court finally determines that the decision was made with the meeting that wasn't properly noticed, you're going to have to start all over again. All right, well, I think we're finished here, so be sure to let staff know that you just did this training and when you had that training done. Keep in mind you have to do this every 4 years, and so we'll see you again in 4 years to go through it again, and thank you for listening today.